What is a withholding agent under federal law? The term withholding agent is defined in IRC Section 7701A, 16, as any person required to deduct and withhold tax on income paid to another. This role is further clarified in IRC Section 1461, which places direct liability on the withholding agent for any taxes withheld. A withholding agent is typically a payroll officer who, after receiving an executed Form W-4 from an employee, becomes liable for the withheld amount until remitted to the U.S. Treasury. See also IRC Section 7809. Importantly, unless a valid W-4 is signed, no legal basis exists to withhold federal income tax, and no liability attaches to either party. Does signing a W-4 carry legal implications? Yes. Form W-4 is titled Employees Withholding Allowance Certificate, and by executing it, a worker certifies their status as an employee under the IRC. However, this status is a legal fiction unless the worker is actually employed by the federal government. Absent a signed W-4, a private sector payroll officer lacks both statutory and contractual authority to withhold federal income tax. The execution of Form W-4 thus initiates both the classification as a federal employee and the presumption of tax liability, a presumption not grounded in statutory law for private citizens. What is a withholding exemption certificate? A withholding exemption certificate is an alternative to Form W-4 and is authorized by IRC Section 3402N. It allows a worker to declare that they had no federal income tax liability in the previous year and expect none in the current year. Upon proper execution, the certificate prohibits the employer from withholding federal income tax. Despite its statutory authorization, the IRS has never issued an official form for this certificate. Nonetheless, the language of Section 3402N permits individuals to draft their own. Numerous institutions, including the California Franchise Tax Board and Johns Hopkins University, have created their own versions, affirming its legitimacy when properly invoked.